Sharon, and I'd like to thank Cleary, Gottlieb for hosting this event and also for playing such an instrumental role in the success of the clinic. And I'd like to thank Sharon as well. And sitting next to her is Lauren. Both Sharon and Lauren Melkus were my interns at Sanctuary for Families back in 2011. And we had the idea that we would like to start a clinic for LGBTQ youth, many of whom are at risk for commercial sexual exploitation. And so we partnered with the Church of St. Luke in the Fields, which has this weekly program on Saturday nights. There are anywhere from 20 to 60 young people, and we have become over the years a really integral part of the services offered. We have an attorney every week and hope that some of you will consider joining our cadre of attorneys. At any rate, we have a CLE tonight, which I hope will be very interesting to you. And we were so amazed because we sold out within days, but glad you're here. And we're going to begin with an introduction to the clinic. And Debbie, my former colleague at Sanctuary for Families, is going to tell us a little bit about the clinic generally and is going to be able to provide an overview. And here is the clicker.
Thank you, Brett. Thank you, everyone, for coming. So I'm going to be doing an overview of the clinic. If you haven't been, again, it's at the Church of St. Luke in the Fields in the West Village. It is weekdays, weekend evenings, on Saturday evenings, and it's part of a larger sort of provision of services that are provided by the church. The program is called Art and Acceptance. And so one of the main attractions there is a free hot meal, a free dinner for the youth. And so a lot of the youth are coming and very interested in taking part in that dinner, but also engaging in the other services that are at the church that evening. So we're one of the services that are available on those Saturday evenings. And I think it's just important to keep that in mind, that we're not the main attraction necessarily for the youth. And so, I think being mindful of that, in providing services at the clinic is very important, that we're not necessarily the top priority. Sometimes the youth are seeking other things in coming to the church for that evening. So again, the legal clinic is one of the free drop-in services that are at the clinic. It's sponsored by LeGaL. And the main coordinators are Brett and Sharon, but also Lauren, who helps schedule all of us. And the purpose of the clinic is to provide free, high-quality legal information, advice and counsel, and referrals when it's appropriate. I'm just going to go over some basic interviewing techniques. So when we're meeting with these youth in the clinic setting, as Brett mentioned, there's 20 to 60 youth, a relatively small amount of space, and there are different people who are providing different services. For example, there's what they call a pop-up shop where they provide free clothes for youth to take as they need. And so that might be one of the attractions that the youth are coming for. It's getting cold, it's winter time. They might be looking for a jacket or boots or something like that. So within that setting, when youth are going to that pop-up shop, we're also providing this legal clinic services. So it's important, I think, within that context, just trying to keep in mind also how to interact with the youth, or sort of best practices in terms of interacting. So these are just some of the tips that I think we thought would be important to consider. One of the main things, I think, is transparency, making sure that the youth understand who you are, understand why you're there, what services that you can provide within that evening's provision of services. Also, a collaboration that, some of the youth may not necessarily identify certain things as legal issues. I oftentimes have youth, I will mention different kinds of legal cases that, they might have or they might have issues with. And then sometimes people will bring up issues like, oh, well, I don't have any legal issues, but I'm interested in a name change. I said, well, actually, that is a legal issue, and I will talk to them about that. So sometimes the youth themselves aren't readily identifying legal issues. So it is a collaboration between them. I think being very open and talking with the youth is important when you are volunteering. This is not on the slide, but just in terms of you're walking into a room, there's sort of two main rooms that the clinic and the art and acceptance programs are sort of occurring in. And within that clinic, within the sort of program, there are youth that are sort of clustered around in the different rooms, and it's just important just being open and talking to the youth, engaging with them, and trying to interact with them and trying to see, whether or not you might be of some sort of service to them that evening. Also, when you are interacting with the youth, we're going to get a little bit more into some of the ethical issues, other concerns, but also keeping in mind a lot of these youth are living in unstable housing situations. Some of them are in shelters. Some of them are sleeping on people's couches. They may be living in sort of very difficult situations, and being mindful of their own sort of physical safety when you're interacting with them. They may have trauma histories. You have no idea maybe what it took for them to get there that evening. There may be a lot of things that have happened to them during that day. I actually met one of the youth, I think the following evening or on the subway, and she was just riding the subway all day because she had nowhere else to go. So it's just important to keep in mind that the youth that you're interacting with may not be like your traditional client that you deal with on a day-to-day basis, and just being very respectful of that. When I am sitting down and working with a youth at the legal clinic, I also am very mindful of physical space. I do not initiate, physical contact with the youth. If they want to shake my hand, oftentimes they do at the beginning of a session or at the end of a session. I'll shake their hand, but I'm very mindful of not touching them or, touching their back or anything that may make them feel uncomfortable. So that's very important too. Being honest, sensitive, I think just sort of the basics of being a nice person, I think apply here as well. I think these youth, you're providing illegal services. They are a client, just like any other client for whom you are providing services to. Being respectful of them, acknowledging your relationship with them, I think is important here as well. Very nitty-gritty, again, of interacting with the youth at the clinic. I will oftentimes introduce myself to the art and acceptance program sort of coordinators. There are certain coordinators there, social workers there that are available throughout the evening. I will introduce myself to them, but then also will go around sort of the room throughout the evening and just introduce myself to different sort of clusters of youth. They oftentimes will have friends that they interact with, and they might want to spend time socializing with their friends, and that's fine. I'll introduce myself, let them know what I'm there for, that I'm part of the legal clinic. If they have questions, they're free to come and talk to me, that I will be around, and I just sort of do the rounds again just to make sure that they know that I'm available. I think that's very important. I think also potentially identifying certain legal issues. I know that we are going to be talking about some common issues that may come up with some of the youth, but it's important, I think, because the youth may not identify, for example, I mentioned the name change, they may not identify certain things as legal issues, that you could bring up those examples. And I think that that's a helpful way to start a small talk with them. Also, in terms of validating experiences, being understanding, being a good listener. Again, this all comes into play when you're doing the initial intake with the youth, talking with them, just making sure that they understand that you're there to listen to them and try to help them and provide a limited service that evening. There may be many people in their life who have promised them things, that have betrayed them, that have lied to them about services that they could provide to the youth. So within that context, knowing that you are there then to, again, sort of be of service to them. But I think just understanding that they may not be entirely trustful of you in that interaction. Unfortunately, the clinic context and providing a service within this limited scope is not necessarily conducive to building trust. But I think within the context of what we have, in, these Saturday evening sessions, doing your best to try to engage with the youth, be respectful of them, and sort of mindful of their own past experiences is important. Also, other basics of, best practices perhaps is using language instead of saying, one example is, do you understand? So sometimes people say that and it's just a very sort of flip way of ending a conversation, just making sure, oh, do you understand what I'm saying? And people also will have a flip response and just say yes, yes, and they'll just nod their head, even though that they may feel uncomfortable, they may not understand everything that you're saying, they may not understand some of the words that you're saying. It is important to be respectful of the youth and try to defer to them in some way towards the end. So common examples that I might use is saying something like, am I being clear? Is there something that I can explain better to the youth, just to give them an opportunity to be able to ask a question? Yes.
Can I ask, what is the age range?
The age range, I think the vast majority are probably like 17 to 24, maybe?
Yeah, with most probably 21 to 26.
Yeah, yeah. It's so there's some that may be a little bit younger, but I think they tend to be a little bit on the older range of youth. Yeah. I guess we're going to. So the next slide is again just some more basics about being present, being kind and considerate to the youth that are there, and also going with the flow. This is something in working with youth in general is important to keep in mind. I again want to reiterate that the legal services in the legal clinic are not the main attraction necessarily for the youth. So sometimes I might have youth and they call people for, the dinner line, and all the youth run to the dinner line, run to get food. And I'm not the priority. They need to eat. So that's fine. And I will just make sure, when I start meeting with the youth, I let them know if they call for dinner, or if you want to go get something to eat, something to drink, that's fine. And just being flexible with that. And just trying to stay calm. I think in the situation, there's sometimes situations where a youth maybe they might get agitated, or maybe there might be some other issue. Maybe something happened earlier that day, or maybe there's another youth there that they've had conflict with. There's always support systems sort of available. There are social workers throughout the program that are coordinating all the services. And so if there's any need for somebody to somehow intervene or to provide support, they're always there. Those are some just basic tips for those who might be interested. And I guess we're going to switch over now to talk a little bit about some of the ethical considerations, and I'm going to pass it back to Brett.
Great. Thank you so much, Debbie. So we're going to talk a little bit about the primary ethical considerations which are present when offering a limited scope legal clinic such as this. And that's really the key term, is limited scope. So many lawyers who are new to this kind of volunteer experience often worry, oh my goodness, am I going to end up being on the hook for whatever case arises? And the answer is no. Let me just move ahead there. So if you look at letter C, short-term limited legal services are services providing legal advice or representation free of charge as part of a program with no expectation that the assistance will continue beyond what is necessary to complete an initial consultation, representation, or court appearance. And so that is really the primary concept of which to be mindful. And we have at the very top of our form, I think I'm going to go ahead and then come back. But this is the top of the form which we use, and it's really important to go over this with the individual who is seeking a consultation, because sometimes that individual may think, oh, you're going to be my lawyer. So we have the person sign this form, but I think it's really important to go over it and make sure that the young person understands exactly what it means. Now, this is the form that all of our volunteer lawyers use, but some of the attorneys from law firms firms may have other other forms which the firm, requires, and that's not a problem at all. I think that the Cleary attorneys may have their own form, but again, the key is to make sure to explain the form to the young person, and also, if possible, to do it in language which is very simple and very straightforward, and not to let the forms necessarily eclipse the wonderful service that's being offered, the provision of legal services, because oftentimes we are the person's first point of entry into the legal system. And so it's really important that it not be unduly difficult with a lot of complex jargon and forms. So the simpler the language, the better. So we think that the language that we have is fairly simple, and we use this for all of the LeGaL clinics. Our main clinic is at the LGBT Center on Tuesday nights, and this is the form which we use and the language we use there as well. I'm just going back now. So with a limited scope clinic, the usual considerations regarding conflicts, of course, apply. However, the rule really is written, I think, with the intention to offer pro bono free legal services. And so the requirement is really knowledge of a conflict, actual knowledge of a conflict, either for yourself as a lawyer or a colleague if you're in a law firm. And in the latter situation, you can in fact say, well, I can advise you only with respect to a limited aspect of what we might talk about. So the law, I think, the rule really is very liberally drafted in order to err on the side of providing the free legal services to clients. Okay, let me move ahead. So I mentioned about the form. Okay, I wanted to mention too, it's really helpful not to have additional business cards from your particular law firm. Now, of course, there may be the law firm's own limited scope waiver, but other than that, emphasize that this is really a LeGaL clinic. You are a volunteer on behalf of LeGaL, just to avoid any confusion between what the entity is which is providing the service. So I think that's an important point as well. I want to move forward to confidentiality. So it's very, very important, and this is somewhat related to what Debbie mentioned before. Many of the young people who are coming to this clinic have very extensive trauma histories, and trust can be a very important issue. And so it's very important to reiterate that anything that is discussed in the context of the clinic is indeed confidential, and in fact is special. I don't really like to use the term attorney-client privilege. I'll mention it, but then I say attorney-client privilege means that the conversation is special conversation, special communication, which means that no one else can have access to it. And I think that often really reassures the young person that it's safe to talk about whatever legal issue the person may be facing. I often find that the following situation arises, which is that the young person is somewhat fearful and wants to have a friend present during the course of the consultation. And so that's where I do my best to explain in layperson language that if you have a friend, that's totally understandable and that's fine, but then the communication is no longer special because now the friend knows also. And then I will go on to say that if there is in fact a case against you, God forbid there will not be a case against you, but if there is and the other side were to know that this friend were present, that friend might be called upon to testify against you. Are you still comfortable having your friend present during the course of this consultation? I think that for me is the most common situation which arises, in which I try to break down what confidentiality means, what attorney-client privilege means, and usually when I do that, I think that it makes sense. But again, I don't necessarily say, do you understand? I use the questions that Debbie alluded to before. You want to
And
answer?
another type of example that it's somewhat related, but it might be a youth who says, within the context, people are eating dinner and says, oh, well, just maybe you can just sit here and we can talk. But there's somebody, less than 5 feet away who can hear what we're talking about. So I also will talk about confidentiality and sort of trying to have a safe space for us to be able to talk privately about their legal issue. And it can be a little bit, I think, complicated at the church. There are different measures that we have tried to develop, I think, over the years to have some sort of semblance of confidentiality and private space. So, one of the things that has been developed is a partition, which creates, essentially sort of like a cubicle for the attorney volunteer and the youth to be able to talk privately. So that should be requested when you want to work with a youth. However, sometimes there's situations where the youth doesn't want to sit in that private space, or the youth may not be trustful of you and may be concerned. There is also a private room where you can also meet. But that also may be very uncomfortable for the youth. They don't know who you are, and you're going into some private room in this church where they may feel like they don't know, how they may be able to exit and enter that room sort of on their own, or whether or not they have to rely on you to be able to leave that situation. So sometimes I leave it up to the youth and just make sure that they really understand the situation. What I personally do is try to find as private a space as possible within the church setting. Sometimes that might be there's a sort of a slight outdoor sort of garden area. And sometimes even in the wintertime, sometimes there's youth that are sitting out on a bench and there's a private space there. Maybe I'll just sit out there with the youth and just make sure that there's no one else around. So I think that's also another way in which confidentiality comes up. And I just make sure that they understand why I'm trying to find that private space with them. Um, um, one other thing that I did want to mention is the actual form itself
Mm-hmm,
that
mm-hmm.
Brett has alluded to in terms of confidentiality. I know with clients in my day-to-day work, but also in this clinic setting, filling out a form, writing down information when a client is talking to you can be, it can be a little bit disturbing or, concerning to them. Who are you giving this information to? Why are you writing down information about me? I will oftentimes show them the form. That's sort of what I do. I will show them the form, show them obviously the informed consent area where they need to sign and go over it with them, but also just show them these are the types of questions that are being asked, and it's within the context of this clinic, and it's not to be shared with anybody else. But that's also an important, I think, tip.
Related to that is the fact that very often the young person will benefit from additional follow up or a possible referral. And so there might be information written down in the form, and all of those forms are then sent to me either later that night or the next week. And so I think it's helpful, especially if it's clear that some follow up might be needed, that the information will be shared with the LeGaL clinic coordinator, yours truly. And what I often do then is contact the person and say, I'd like to put you in touch with David Miranda at the Urban Justice Center. May I do that? May I share the information? So I think if you can explain, especially if it seems like a case for which follow-up is necessary, that information will go to the clinic coordinator and may be passed along with the young person's consent to the organization to which the case is referred. Um, let's see. I think we were on confidentiality. Competence, yes, thank you. So competence, one of the concerns that many volunteer lawyers ask me when they first consider volunteering for such a clinic is say, well, I do securities litigation, and what do I know about criminal defense or family law? And I say, you would not believe how invaluable a service this is because, again, it is the point of entry for so many people. And just to clarify the legal issues is so helpful. So don't be dismayed if it's not your area of practice. I often say, too, that it's really a lot like issue spotting on a law school exam. So it brings you back to law school. But you do not have to be an expert in any of these practice areas. And in fact, I think it's really important when there is a legal issue which arises to say, this is not my area of practice. However, I can talk with you about some general principles of law. That's sort of my caveat language all the time. And, and we can perhaps refer you to an organization or a lawyer who can be very helpful with your specific legal issue. Um, so I think that that kind of caveat language is helpful all the time. You know, another issue which comes up is when the young person may in fact already have court-appointed counsel in a criminal case or perhaps in a family court case. And so this is an issue which I think caveat language is very appropriate. Again, I will often say, well, I think you should consult your lawyer. But when I've had cases like this is what I often tell my client. Now, I am primarily a family law practitioner, and those are often common cases which arise in the context of these clinics. So I feel comfortable with respect to family law, but again, that may not be an area of expertise or a practice area for a securities litigator, say. So always be sure to say, I suggest you talk with your assigned lawyer with respect to general principles of law or even general legal procedure, what it means to have a court date, what it means to appear, what it means to have a lawyer. Sometimes that gets back into the confidentiality and privilege language. So all of that, I think, is entirely appropriate. David, you before said you wanted to say something about that situation, especially with respect to desk appearance tickets.
Right. So sometimes you're gonna come across something called a desk appearance ticket. What that is that somebody was taken into a precinct for an alleged crime, and they were given a piece of paper that says you have to come back to court on X date, on let's say October 31st. And before that date, before that initial date that's on that desk appearance ticket, that person will not have been assigned a lawyer. So at that point, at the very least, what you can do is let the client know. You can either say, I will contact a lawyer that you can talk to before your desk appearance date, and that lawyer could represent you. Or you can say you have a date in the future where you're going to come back, and on that date, which
That's when you'll be
which
assigned.
Anthony will explain, on that date you will get a lawyer and you will be arraigned. And by the end of this training, my hope is that you guys will know everything about an arraignment, and that you'll be able to say, and this is what an arraignment is, and this is what's going to happen on that. This is what could happen on that date. And so with desk appearance tickets, it's a little bit different because that person has not, in fact, been assigned a lawyer.
I wanted to go back and mention something about scope as well. Very often, a young person will come to the clinic week after week or a month later. And so it's very important to mention that the limited scope is for that session only. And as a practical matter, sometimes the young person thinks that you may recall what you said a month ago or 2 months ago, or that you may know telepathically what your fellow
Yeah.
volunteer advised the young person a week or so ago, or whenever it was. So I think that it's important to reiterate that the consultation is only for the purposes of that particular consultation, because the reality is that there will be young people who come back for repeated consultations. Now, this, in fact, may change with technology. I just want to mention that one of the things we're hoping to do at LeGaL is jump into the 21st century in terms of referrals, and we want to be able to make referrals at the click of a button and have information uh, on an online system accessible via by our volunteers. But for the time being, there is no repository for the forms. It's still a paper method, and so you can reiterate that you don't know anything that was conveyed to a previous attorney. But stay tuned for another CLE when we do face issues related to having those forms accessible to our volunteers. Were there any other?
One other thing that I
Yes.
wanted to bring up in terms of the competence and potential referrals back to an attorney of record for that young person. I will oftentimes will write down information for that young person. So if I know that they're represented by legal aid or somebody else, I will write down that person's information. I'll write down the address. I'll make sure, do you have a Metro card to be able to get there? The staff at the church do have Metro cards to help people get to appointments if they need to. So I will try to provide that information. Some of the issues that I come across too are situations where people are represented. Maybe they don't know when their next hearing is. They don't know what stage of their proceeding that they're in. Maybe it's in a criminal context, and I'm able to look up that there are sort of public websites in New York to be able to see ongoing cases. And so I will just on my phone look up that information. I'll see who the attorney is and say, this person is your appointed counsel. This is their name, this is their phone number. I will look up on their website, give them the website information, ask them, do you know how to get to this place? And encourage them to make contact that way. But I think oftentimes, like giving somebody something in hand when they walk away is also something satisfying for the youth.
Thank you. So with that, I think we're going to move forward to some of the substantive issues and turn it over to David Miranda. And I will mention that his arrival at Urban Justice Center was met with so much glee by every legal services professional in the city of New York because he does criminal defense for LGBTQ youth, and that is such a need. So you may be currently the only one or one of a very small group of individuals. So we're very thankful to have you here and to be able to refer cases to you. So thank you, David.
So actually, yeah. So it's a completely new practice. I started in June, and we are starting. We traditionally provided civil legal services to homeless and street involved youth 25 and under, with a focus on LGBTQ youth. And this is the beginning of a criminal defense practice for that population. So just to talk about a little bit about the youth that you're going to be seeing at the clinic, as Debbie was saying, they come in with a lot of issues other than the LGBTQ, right? We like to think of people in a box, like we're doing LGBTQ work, but in reality, they're dealing with a myriad of issues, such as the fact that they're young. They deal with racial discrimination. They deal with poverty. They deal with, sometimes you will come across people with mental health issues. Sometimes you will come people with substance abuse issues. Sometimes a person, and I don't know how often you guys come across this at the clinic, but sometimes the person might come to you asking you for a consultation, and you might suspect that they might be under the influence of some kind of substance. And I would gather that the social workers that are on site would be useful people to talk to about that when you're beginning to have that conversation. They also often come in with immigration issues. Sometimes you have clients who might you need to find out, is this client an American? One of the questions you want to ask, especially when somebody has a criminal issue, never assume. You always ask somebody, where were you born? Right? You're not asking, are you an American citizen? Because they might say yes. In fact, they don't know that they're actually not. So you want to ask, where were you born? So at least you know that that's an issue that you have to be mindful of, or the criminal attorney has to be mindful of, or the client has to be mindful of when dealing with their case. They're also dealing, obviously, with gender and sexual identity issues. There are people who LGBTQ includes a very wide spectrum of people. There are people who are cisgender. There are people who are gender nonconforming. There are people who are transgender, right? And you don't every one of those is going to come with a very different set of variables. Typically, the clients that I see are poor and uninsured. Disproportionately, they're members of their people of color, often homeless. As you as some of you will know, 40% of homeless youth identify as LGBTQ. I would gather that so far, at least in my practice, I think that number might actually be higher. I don't know if that's the nature of just the organizations that we work with, but I would gather that just by virtue of being LGBTQ, you're more susceptible to being homeless, or you're more susceptible to having contact with the criminal justice system because of family rejection, because school is not a safe place. I don't feel safe going to school, so where am I going to go? I'm going to go and be out in the street. And in the street, there's a lot of potential for criminal justice contact, as well as other contacts that might not be safe, right? Um, our clients will come into an arraignment, and this might be outside of your purview because you're meeting clients sometimes before they have an actual court date. But if they are arrested, they might be more susceptible to remaining in or being in prison or in jail for a longer period of time than somebody who's not homeless and young. And the reason for that is that I and again, I know we might disagree on some on these points, but one of the things that a judge has to consider when making a decision as to whether or not they're going to release a client at an arraignment, meaning the first appearance where the decision that the judge has to make is, am I going to set bail on this person or not? One of the things that they have to consider is whether this person is reliable. Is this person going to come back to court? And in the criminal justice system, I think that there is a perception that people who are young and homeless, it's like a perfect storm. They're not considered reliable. So I think that for our clients at least, when they're arrested, and especially if they have a longer rap sheet, sometimes they might have a very big rap sheet for very minor offenses, such as various misdemeanors for hopping the turnstile over and over again because they were trying to get to wherever they had to go to, but they couldn't afford it. So the rap sheet is this big. They've warranted a couple of times because of whatever issues are going on in their lives. The judge sees that and is like, I'm going to set $500 bail because I don't believe you're going to, I mean, they're not going to say it, but the idea is you're not going to come back to court. And then your client's in, or from my perspective, my client's in until the case is over. Or my client might take another plea to yet another letter to another misdemeanor count of jumping the turnstile, even though they might actually feel that they're not guilty because they don't want to go in or they don't want to spend too much time in jail. So our clients being homeless and young will often affect the outcome of a case just by virtue of the reality that bail can be set, they're seen as unstable, and even small bail is really tantamount to remand because if they're homeless, I mean, $50 is a lot, right? Just another point in New York, you're criminally responsible if you're 16. New York is one of only two states in the entire United States where the age of criminal responsibility is 16. The other being North Carolina. I don't know why that is, but somehow we are behind the curve on that one. As you can see from this chart, LGBTQ youth are, there is an overrepresentation in the criminal justice system. Of all youth in the juvenile justice facilities, it's tantamount to 20%. Of boys, that's 14%, and of girls, that's 40%, with 65% of those youth being youth of color in the facilities. I would argue that discrimination pushes LGBT youth into the system for various reasons. As I was saying before, family rejection, family instability and poverty, homelessness, unsafe schools, failures to the child welfare system, school to prison pipeline, right? And we want to think about when we say school to prison pipeline is why are certain students categorized in a certain way? Why are certain students that identify as LGBTQ youth termed at-risk youth from the moment that they're in school, right? So if I'm LGBT, I'm a young man and I'm in school and I don't feel it's safe to go to school, so I never go to school. What happens then is they're like, well, you're never going, you keep cutting school, so we're going to put you in a special class where we put everybody who doesn't go to school and we're going to try to keep you in school. And then you're deemed by the school a problem child. And then you're deemed by the school, you're more likely to be suspended. And that's actually going to make me less likely to go to school, right? So then that creates a perfect storm of I'm no longer going to school. I'm going to be out in the street. And then bad laws and policing strategies that target LGBTQ youth, whether that's the law itself or discriminatory enforcement of the law. Who gets arrested for what? One of the things that troubled me when I was a public defender in the Bronx was that a lot of the young people that I saw that were arrested, sometimes they would get arrested for things that just young people do. I mean, and I understand that maybe they weren't, but it's like who gets arrested for what? Sometimes these laws are not all enforced. It's like it's just like how are these laws enforced, right? So you see a group of there's a group of young men of color who are walking down the street. They get into an argument, they get into a fight, and that's charged as gang assault, which is a very serious crime. But it really was a fight amongst young people. I'm not saying that it's right, but these laws are not enforced the same in every single place, right? And a lot of the clients that we see, especially with young people who are LGBTQ, what I find in my practice so far is that I find that a lot of them are coming in for really, really minor offenses. So you're not, I don't know what your experience has been, but I don't know that you're going to see a lot of like the very, very
Yeah.
serious stuff.
What did I do?
You're probably going to see a lot of turnstile jumps. You're probably going to see a lot of maybe summonses for like open containers or being in the park after dark because you have nowhere to stay, or trespass. I had one case that I picked up that it was a trespass because the client was sleeping in NYCHA housing. They had NYCHA hallway because they had nowhere else to stay, right? And they kept getting picked up for that. And it's like, okay, so that's something that we're criminally prosecuting, but that's also like the reality that our clients have to deal with. And it's like, is that something that should be criminally prosecuted, or is that something that maybe the system should be taking a better look at and say, where did we fail? But you're gonna wind up seeing some of those
Mhm.
things. The other one is the enforcement of anti-prostitution statutes, especially when it comes to some of our trans clients. The specific provision that I'm talking about is Penal Law 24037, and that's loitering for purposes of prostitution. And there is a push now to change that law as unconstitutional because a lot of times people will get stopped in the street for just walking while trans in certain areas, and the statute itself, if you read it, it reads as if you're in a certain area and you're stopping traffic for purposes of prostitution or like creating some kind of like you could be hailing a cab. But when you get these complaints, what we see as defense attorneys is they were on the area of in the Bronx, for example. It's a gathering place for trans clients. Yes, there might have been some sex work going on in that area. It's on the area of Jerome and Fordham in the Bronx, but it eventually became just a gathering place where trans women would go and find each other and meet each other and hang out. Like that's just what it became. And what wound up happening was a lot of trans women were being arrested just for being in that area, and they were like, I wasn't engaging in any sex work. I was just walking down the street, and the police would stop them. And the complaint that we would get when we read it as defense attorneys is this person was walking down the street of Jerome and Fordham wearing a short dress and high heels. And it's like, I don't know. It's like, how do you decide who's there for prostitution and who's there for just to meet with their friends? Common offenses that you will see violations, which Anthony will talk about. Those are not crimes. There's felony level crimes, there's misdemeanor level crimes, and then there are violations, which are not crimes at all. But what I will be wary of is that violations sometimes do have very serious, what's called collateral consequences, even though they're not very collateral, especially
Mhm.
in the context of the immigration context. You will see that, for example, 24026, which is a harassment violation, which is not a crime at all, can make someone deportable in certain circumstances if it's a DV case, for example. Or a 22105, which is for marijuana, can also make somebody deportable. And those are all things that you're like, oh, it's a violation, but you have to be mindful that it can have very, very serious collateral, like other consequences for the client, even if it's not a crime at all. And then the disorderly conduct, which is referred to as a 24020, also a violation and not a crime. It's kind of a catch-all. If oftentimes as a means of reaching a disposition on a criminal case, we will the client will end up resolving the case by pleading to a 24020, because in general, and again, if you're working with a client who's a non-citizen, you should always consult. I would always consult with an immigration attorney, but in general, a 24020 is generally safe. But you still have to be wary that it might have other collateral consequences. Public lewdness, which again is enforced, I think, sort of. I mean, I don't know if you guys read the article in the New York Times that came out about a year and a half ago about how they were trying to stop men who were perceived as being gay, who were using the bathroom in certain public areas. They were doing stings and arresting them for using the bathroom because they were perceived as being gay using a public bathroom in New York. And that was actually a sting that was done by the New York City Police
Grand Central.
Department, right, and Port Authority. And then the prostitution, as I said, those are also they're not enforced the same, and it is a defense to a prostitution related offense that you were a victim of trafficking. And also I would encourage you, if you do see somebody who says I have a number of prostitution related offenses, or I think I have a number of prostitution related offense on my rap sheet, to make a referral, either to legal aid or to me even, because those, if you can prove that the person is a victim of trafficking, even if they have 100 prostitution convictions, you can get rid of the person's criminal record if it's only prostitution. And I've actually in the Bronx, we actually had a case where we had somebody have 50 prostitution convictions wiped off their rap sheet, and she has no criminal record, which is awesome. I would say. So just I want to talk about, some of the issues that our clients are facing are the issues that you see in the news right now with the police, right? They are there's profiling that goes on. There are these quality of life offenses that are really minor things that in other communities they might not necessarily be arrested for or get a ticket for, but that's how they come into the system. Being young and of color in the current climate, who gets arrested for what, which is some of what I was just talking about. And then there's the issues of what kind of contact they have with the Department of Corrections. There is distrust. There is distrust of the police. You're probably going to come across some people who are like, I am a DV victim. I am a DV victim, and I want to make a complaint, but I'm afraid to go to the police. Right? There's distrust on both ends. There's distrust both from the people who are victims of crimes as well as the people who are accused of a crime. After arrest, the DOC and the court system may not respect the gender identity. I've seen that as a particular issue in where I was working in the Bronx. They would every single one of my trans client would be complaining that there were certain corrections officers in the back who were saying, you're just confused, you're a man, you're this, you're that, and just like like really being disrespectful to the client's gender identity. And if a client comes to you with those sorts of issues, then you want to see if you can get a general description of who that person was, or if they have a name. And then there's something called a notice of claim, which should be filed within 90 days. You wanna make the referral for that, and that's actually a civil issue, so that might be handled a little differently. Judges and juries and judges, again, this all affects the disposition of a case, right? How good and how bad. Like, there are great judges in each county. In I'm particularly thinking in the Bronx. There's one judge who was very cognizant of the role that bias plays in a lot of these arrests. And one of the things that she did was she actually organized the district, that she had the district attorney's office, her office. She was in charge of the APA part, which was the sex trafficking part in the Bronx. And what she did was she had us all of the Bronx Defenders Legal Aid, members of the trans activist community, as well as the Bronx DA's office, and community leaders, and sat us down to talk about the issue of why, and the police department, and why the trans women were getting arrested when in fact they were doing nothing wrong. And what came out of that was we went to the precinct in that area of Jerome and Fordham, and we actually did a cultural competency training for them. And we found that the arrest went down. I don't know if the harassment stopped, but at the very least, from the judge's perspective, what she told me was that the arrest went down. So, and then there are very bad judges. There are judges who won't, you know, they won't respect our client's gender identity, or they'll say, "Oh, you're using an alias. That's not your name," and call the client by their wrong fully pronoun name. And so it's there's a gamut of the client might be dealing with they might be dealing with a very good situation or a very well, always a negative situation, but it could be worse depending on the judge and the jury. Also, the defense attorney, because that's the defense attorney is the person that they're dealing with the most, right? God forbid the client gets a defense attorney that won't respect their gender identity, then they're going to be then they're going to have to deal with that issue as well. In general, I think that the especially the institutional providers are very very good with respecting gender identity and do come from a place where they understand these issues. But there could be a random situation where you have somebody who's like, my defense attorney doesn't mispronouns me or is saying offensive things to me. You want to get your client acquainted with the court process. What is a day in court like for our clients? The reality is that it doesn't matter. Um, it's going to be frustrating. I mean, there's really no way around it. Even if they get a DAT and they're gonna go in, it's a frustrating day. It's a long day. They might be waiting there all day for their attorney. The reality is that you have to get the reality is you have to get the client prep for that. That really is a service to the client because especially young clients, they they don't like to wait, and sometimes they'll get there if they get there early they'll be like, "Well, my attorney's not here. It's been an hour," and they'll just leave. And in leaving, there's a warrant then out for their arrest. So you want to make sure that you just prep them for the fact that it's going to be a long day. They're going to wait around. Um, Ask the client if they already have the attorney, if the case is ongoing. Ask the client to get in touch with their attorney the day before. It really makes all the difference in the world. If I have a client calling me the day before and saying, "Hey, I'm going to be there right at 10 o'clock, or I'm going to be there right at 10:30," and I'm like, "Okay, cool. I know to go there first, right? Especially if I have 5 different parts that I have to be in that day. I know that's where I'm going to go first, and I can get the client in and out." So sometimes you can help. Just explaining little things like that can make a long difference. Even though you're not giving legal advice, but you're at least making it a little easier for the client to deal with this very frustrating system. Going back to your point about the defense attorneys and finding them on web crims is the public access system where you can look up whether a client has a pending criminal case. And what I will say about web crims is that it's great because I can find out if somebody has an active case, especially if they don't know. But what I will also say about web crims is that it's almost always wrong when it comes to who it says is the attorney. So what you want to know is I have a whole list here in the PowerPoint of the different institutional providers. You will see, for example, legal aid is the catch-all. So legal aid is in all 5 boroughs, but the problem is they're a conflict attorney. So if if it's in the Bronx, it could be one of three, right? It could be either legal aid or Bronx defenders or someone on the 18B panel. Chances are it's going to be one of the first two. But what I would do in that kind of situation is I would give the client both legal aid and Bronx defenders, and then have them call both and
Yeah.
see if they can contact their
Yeah.
attorney that way. Because 9 times out of 10, web criminals is wrong.
No, sometimes I give them multiple information. I say, or sometimes they're looking to talk to a criminal defense attorney, and I say, okay, I'll give you a couple of different places that you can go to in your borough. Go talk to them. They might be conflicted out for an issue or something like that. But yeah, definitely giving them more information is helpful. And then also managing their expectations. Yes, this is a public website, and I do tell them this is a public website. This is what it says. You should call these people, but maybe there's been a change, especially if you haven't heard from this person, if you don't have regular communication. Maybe there's a new attorney. Maybe even within that office there's a new
Right.
attorney that's working on the case. So I always try to manage their expectations as well.
For CLE purposes, today's code is 000104116. I repeat, 000104116.
With
Right.
information.
And I'm always, I mean, especially with DATs and summonses and stuff like that, I'm always available to deal with those issues, just to put my own pitch. But Oh, just the last point. Warrants. If you come across people who warrants, there's one of two reasons they could have warranted. Or one of a few reasons they could have warranted. Actually, the word warrant, first of all, it means a lot of different things, but the legal warrant. Let's say they miss a summons date or a DAT date. Chances are they don't have an attorney, so that's a very different type of warrant. So you always want to ask, have you already been to court on this case? Because if they say yes, chances are they already have an attorney, and at that point, you want to see if you can reconnect them to their attorney, or at least give them the information so they can reconnect themselves to the attorney, so that they can go back and then turn themselves in on the warrant. The other type of warrant that's not really a warrant at all is an investigation is being done. The police are looking for me, and I have no idea why they're looking for me. Then that's not a warrant at all. That's something called an open 61, and that you can actually call for that. I would actually. I don't know. I mean, you can call Bronx Defenders or those agencies to do a general intake, but for that as well, you can call me or you can call another attorney, and I can actually go with the client to the precinct, invoke on behalf of the client so that they're not put in a lineup or questioned by the police without an attorney present, and then maybe arraign the client if I have the capacity to do that.
David, thank you so much. And now I'd like to turn it over to Anthony Perrotto, who, in addition to being one of the most stalwart of our clinic volunteers, is soon to be an ADA in the Bronx in the Domestic Violence Bureau. So no?
No. Maybe you know something I don't.
Okay. But I'm glad that we have both the criminal defense perspective and a prosecutorial perspective, sort of.
Well, for the record, I'm currently a court attorney, so I have no perspective because the judicial side is unbiased.
Yes.
Just pointing that out there. So basically, criminal procedure 101. So none of us in this clinic context are really going to take on cases the same way that someone like David is going to take on cases. But we need to be cognizant basically of, well, do we have basic competence and knowledge of what criminal procedure is and what criminal law is? Because the majority of us, including the clients, what we know of criminal law comes from Law and Order. And if it really happened that way, my life and my judge's life would be so much easier. 3 days later, you're in court, there's a trial, there's a verdict, you're done. Does not happen like that. You're on board with that?
Yeah.
So, what we're really going to do is just kind of go through the main concepts of criminal law and procedure. We've all heard violations, misdemeanors, felonies, and there's the A, the D, the C, the Q. Like, everyone's like, what the heck do these kind of mean? They all mean something different. This is not really to make you guys an expert to take on a case, but enough to really kind of give, a walkthrough to the client who may or may not already have a defense attorney when they come to you in a clinic context. So first up is a violation, as David said. So a violation, it's an offense. An offense under the law is basically anything. It could be traffic ticket, it could be violation, misdemeanor, or felony. But a violation is not considered a crime. So what a lot of people are worried about is they say, well, if I plead to disorderly conduct, which, as David said before, is a violation, and get my case over with, am I going to have a criminal record? I'm a teacher, or I want to be a teacher, I want to be this professional. Is it going to ruin me? And the answer is it doesn't add to your criminal record. So while it may come up in the future, such as warrants, when a judge has to look at your rap sheet, they'll have that information in determining, well, is this person trustworthy or not to come back to court? But an employer is not going to have access to that information. So an employer can't Google your name and say, oh, David got a 240-20, I'm not going to hire him. That stuff doesn't come up. And even though it's not a crime, although I've never, ever seen or heard of it done, it's technically punishable by up to 15 days in jail. So anything up to 15 days in jail is a violation under the law. And then after that, which is a little more serious, are the misdemeanors. So we all have heard of the misdemeanors, and David gave some good examples before. Theft of services is one of them. Harassment can be one. Prostitution, menacing is another big one. Trespass. So basically there's 3 types of misdemeanors. There's the A, the B, and the unclassified. If you ask me why something is unclassified or what it means, I have no idea. I don't think anyone actually knows really why. They just didn't give a classification for it.
I think usually it's VTL offenses.
Usually it's, yeah, but sometimes, they just kind of whatever they want to do. The legislators, how much coffee they had that day, I have no idea. But B misdemeanors, which are the less serious misdemeanors, is anything that's punishable by up to 90 days in jail. So if it's up to 90 days, it's a B mis. So if it's between 15 days and 90 days potential, it's a B misdemeanor. More common are the A misdemeanors, which you can technically get up to 1 year in jail and technically a $10,000 fine. Now, while I've never seen this done either, never heard of this done, it is technically permissible by the statute, which is something we'll get into later, why this could be a problem for our clients, especially our tech-savvy young clients, if they have access to the internet. And a felony is the most serious offense possible. So they range from E all the way up to A. So these are generally the much more serious cases, which you more than likely are not going to come across if you're doing a clinic type consultation. These could be everything from burglary to rape to homicide. It crosses the entire gambit. If you do have someone who approaches you saying that I was arrested for a felony, 98% chance they already have an attorney, and tell them to speak to that attorney because they've already generally been arraigned and will go through that process. In some cases, a DAT, desk appearance ticket, E felonies can get those, very rare, but we'll get into that a little later. But with felonies, because they're so serious, and David laughs as this slide goes up, because no one understands what this slide is. This is technically felony sentencing. So if you're convicted of a felony, that's a C felony, that you're a predicate, determinate, indeterminate, you could be this many years, between this many years. Judges can't read this. Court attorneys can't read this. Defense attorneys and prosecutors can't read this. No one understands really what it means. Well, they do, but, there's a lot of confusion behind it in the sense that, it's very confusing for us as attorneys and judges to know what the possible sentence could be for felonies. How do you think our youth or people who come into the clinic who are trying to understand their own case, like myself when I am sick, I go on WebMD and become my own doctor, how they're going to understand it? So whenever you meet, for me personally, and Brett has heard me say this a million times, when you meet with a client for the first time, especially youth, my first piece of advice is don't Google, because a little bit of information in a criminal context can be very dangerous. And that goes back to what Debbie was saying about creating a safe and trusting environment with these youth, and really, sitting down and explaining things piece by piece. If someone was arrested for jumping the turnstile in New York, technically that's theft of services, which is an A misdemeanor. So if they look up online, they say, okay, I was arrested on my DAT for theft of services. It says this is a class A misdemeanor. I wonder what's the possible sentence for that. And they go to Google and they type in A misdemeanor punishment. They're going to see up to 1 year in jail and $10,000 fine. You're going to have a heart attack, and they're going to be extremely anxious, and they're going to be extremely nervous. So it's our job, as attorneys and as advocates, especially in the clinic context, to reassure them that, while that's the case, it doesn't generally happen, and you can explain the process to calm them down, but they should really seek out their assigned counsel in the case. And that goes back to our competency. So I know you guys have probably a better drawing in your handouts. So this is the path of a criminal case. So we're going to go through the misdemeanors a little more slowly, but just overall, so how does any criminal case start? They have to be arrested. So there has to be some type of accusation or complaint made. And what it is as you go down, as you know, felony is a more serious crime. So a felony in New York, you have to be indicted by a grand jury. So what happens first is you get arrested, you get brought in, and then you go to criminal court arraignment. And arraignment is essentially the very first time that there are formal charges brought against you. You all have heard, or seen on TV, they'll say, oh, Debbie, you've been charged, with burglary. How do you plead guilty or not guilty? And you inputting that plea is when the criminal, and they're read to you, that's when the criminal charges and the action is really brought up against you. Now, in New York, for a felony, what it is they're usually set bail in a felony case. So either they'll be set on remand if it's a serious case and a flight risk, which means there's no bail, they're stuck in for the duration, or there could be some type of bail, whether it's $500, which may or may not be remand in some cases, or it might be $10,000, $100,000. In New York, they then have 120 hours to present your case to a grand jury. And the grand jury needs to vote if there's enough reasonable cause to bring these charges against you before the action can take place. So it's 120 hours. The prosecution has to do that, or 144 if a Saturday, Sunday, or legal holiday falls within the week, which it almost always does. So I don't know why they don't just say 144 hours. Again, I'm not a legislature. So what it is, a lot of people ask is they say, well, what happens if they don't meet their 180/80, which is they don't bring the grand jury charges? Then the person is released on their own recognizance. So a lot of people get confused. They think, well, they didn't bring grand jury charges, on this assault with a gun case. I'm free. No, you're not free. You're released on your own recognizance, which is you can go home, but the case against you is still pending. And that's something really important to know. If somebody says that, well, I was in and then they let me out because they said that they didn't have an indictment or something of that sort. It's a reminder that the case is not over and to still, maintain contact with their attorney and all their appointments. So generally here, generally when you guys will see a client in a clinic context, it'll be right before the criminal court arraignment. You guys are going to get they're usually going to bring into you what's called the desk appearance ticket, which David mentioned, which we'll see in a second, lists all the different types of the offense that you're charged with, the date you have to return to court, and where you have to go to court. So the best way to do that is essentially let's meet our client and go through this together. So this is our client, John Doe.
Thanks,
So,
Anthony.
unfortunately, John Doe has been issued a desk appearance ticket. So you're at the clinic, you decided to be gracious and volunteer with us on a Saturday, and John Doe comes and says, hey, Anthony, I got this desk appearance ticket. It has a lot of crazy lingo on it. I'm not sure what it means. Can I just ignore it? They didn't bring me to court right away. Am I let go? Well, the answer is no. You're not free. You have to go back to court. And there's a lot of language on here. It says if you do not appear, a warrant will be issued, and then you must, come back and answer for that charges, and we'll charge you with more crimes than your firstborn child. But that's the kind of stuff that you need to explain to your client in layman's terms. It basically means when you're told to go back to court, I highly suggest that you go back to court on that date, because if not, it's not going to be an easy road going ahead. So the most important stuff in the DAT that you're going to get is going to be on top. So you need to see what really is the important information here. Well, I think one of the most important pieces is what the heck is my client charged with? What was John in this case charged with? So here he's charged with 220.03. Which we'll get to in a second what that means. So we know we have an offense, and thankfully all of us attorneys, I think we all have smartphones. We can Google and say, okay, what is penal law 220.03? So we at least know to tell the client what they've been charged with. Because I don't know about you, Debbie, in the clinic, but in the Manhattan clinic on Tuesdays, I've had people come in with DATs and they say, I have no idea why I was arrested. I have no idea what I'm being charged with. And then you look it up and it's like, well, you've been charged with, public lewdness. So like, oh, really? I had no idea. So you really want to inform the client. The date, it's in the smallest print ever, and people miss it all the time. They always ask, when do I go back to court? When do I go back to court? It's always there on the right side of the piece of paper. Do not miss that date. And combined with that is a location. Most of us here know the different criminal courts in the different boroughs. 100 Center Street is obviously here in New York County, Manhattan. 120 Skirmamorn is in Brooklyn. You have 215. They change the address for the Bronx one all the time, but it's Family Court, Criminal Court. 215 in the Bronx. So you really need to know what borough you're in, because that's also going to determine where you give your referrals. So when you look up, okay, I'm going to refer you to legal aid to talk to somebody. Legal aid is going to say, well, what borough were you arrested in? And a client may say, oh, I was arrested in the Bronx. And then you look at the thing and see it's 100 Center Street. It's actually in Manhattan. So it doesn't go based on where you live, but where the crime was committed, which confuses sometimes some people. And the time. The time that goes along with it, it always says 9:30 a.m. or sometimes 10 a.m. It never, ever, ever ends up being at 9:30 a.m. which, I mean, everyone here, I think most people here have been to court, whether it's civil or criminal, and you know that the thing that we spend most of our careers doing is waiting for judges and waiting for clerks and waiting for things to get started. It's no different in the criminal context. I always refer to these appearances, arraignments as cattle calls. And I warn the client that comes in, I say, listen, it says get there at 9:30. Get there at 9:30. Even if your attorney doesn't show up, do not leave. You may be there, till lunch. You may be there till 2 o'clock, 3 o'clock. Just hunker down, because if you leave, you're gonna end up going back anyway, and it's just gonna end up being more difficult. So you're gonna have to do it once, or you can do it multiple times for an arraignment. I'm sure you've had clients walk out on you before.
Well, the thing is with DATs is that it's not about us, right? Because we're there anyway. We're working that shift anyway. Like when I was Bronx Defenders, that's my DAT shift. I'm gonna be there all day. It's when the client puts their paperwork in the basket, and then we gotta wait for the clerk, and then we gotta get the file. So the client, meanwhile, might have been there at 9 o'clock, and we don't get the paperwork till 1, till 12, and then the lunch break happens. Then they have to get back, and they might not get called till 3.
Yeah.
Yeah.
So it's just a long process, and some of them are gonna get annoyed. I know this may seem like a trivial point to bring up to a youth, especially, but they don't allow cell phones in the courtroom, and a lot of people get very testy when they can't play Angry Birds while waiting. I found, so, myself included, I'll admit it. So tell them, be prepared. You can't have your phone, you can't watch a DVD, which I've seen happen before, in the middle of it. So just advise the client you're in it for the long haul. Just hunker down, and then you'll be assigned an attorney at that arraignment who will be there. So always remind them you're not there alone. I'm here with you at this consultation, and when you get to an arraignment, while it may be scary, a lot of things going on around you, there's going to be an attorney there who's going to be by your side. So, question.
So if you show up at 9:30, is it ever possible?
If the paperwork's not ready, the DA has to prep the paperwork, and sometimes you'll get there and they'll be like, "Your paperwork's not ready," and then they'll give you another date to come back.
Yeah, it can happen. They've been, especially in the Bronx, they've been pretty good at getting around to it recently. There's a new DA in the Bronx who's been pushing. But it can happen. And unfortunately, it's kind of the nature of the beast. We live in one of the most densely populated cities, around. So with the amount of crimes, there's only so many judges. There's only so many defense attorneys, only so many prosecutors that, it sometimes, unfortunately, may happen that way. So what was John, charged with in this case? So John was charged with criminal possession of a controlled substance in the 7th degree. I'm not naming the substance he was charged with. You guys can leave that for your own imagination. So this is a simplified definition of the statute, but a person is guilty of a criminal possession of a controlled substance when he or she knowingly and unlawfully possesses a controlled substance. Thank you, legislature, for the obvious. So in this case, what's the most important thing for us to know besides what was he charged with? We want to know the grade. We want to know what level of offense is this. So this is a Class A misdemeanor. So we know that it's not a felony yet, and that they're going to go back and they're going to be given a deal. So you can explain to them, well, a Class A misdemeanor is the highest level misdemeanor possible. It is not a felony. Generally, there can be jail time in these cases, up to a year, but that's not necessarily the case. And kind of walk them through, the steps of what happens with a misdemeanor plea. So what they want to know generally is, okay, I'm going to go to court, and what's going to happen? What's going to happen at 10 o'clock, and then 10:15, and then 10:30, and they want the play-by-play, which is normal because it's a very frightening and terrifying experience for these, for these youths or any of these clients. So what happens at criminal court arraignment? Like we said, it's a cattle call, essentially, and you wait for your case to be called, and you plead guilty or not guilty. After that point, right before that point, generally the prosecutor will offer a disposition to the defense attorney who's been assigned to the case for the day, whoever is waiting from legal aid or Bronx Defenders, whoever it may be. And they may tell the client, like, okay, you're charged with an A misdemeanor. If you plead guilty today, because it's your first offense, they'll give you a violation, a 240-20. It's not going to give you a criminal record. A lot of people at this point, in my experience, will say, I'm not guilty. I didn't do anything. I'm not going to plead guilty. Again, I'm not a defense attorney, so I can't speak to the interactions between client and defense attorney at the arraignment stage, if, people push more to go forward. But let's say that John over here refuses to plead guilty because he is affirmative in saying he is not guilty. So what happened? So we enter the plea of not guilty. So after that, the judge is going to do what the judge does best, gives you another date to come back to court. And what we know in coming back to court is there's going to be a lot of waiting again. So what generally happens at the all-purpose part is they give the defendant another opportunity to plead guilty and take a disposition, generally something less. But most importantly, it's a control date. So I know that everyone here has heard of speedy trial. And in New York, we codify, our right to a speedy trial by CPL 3030. So basically, all that means is that the prosecutor's office has to state that they're ready to proceed with the case, which means that the complainant has signed the complaint, the officer has signed the complaint, that they have everything that they need to go forward. If it's a misdemeanor, they have 90 days to do that. If it's a B misdemeanor, 60 days, a violation, 30 days in which they can state ready. The problem is that there's a million exceptions which stop that clock from running. So a judge, anyone here that's done civil practice will know that a judge will give you a date and they'll say, okay, come back in 9 months because it's the first calendar date that I have available. Well, that would destroy any type of speedy trial provisions that we have in New York. So anything such as motions that are going to be filed toll the speedy trial deadline. Consent by a defense attorney, possibly to get a better disposition, that stops it. If you're doing discovery in this case, that stops the speedy trial clock. So if a prosecutor can say, for example, well, I'm not ready today, but I'll be ready, my officer will be ready on Thursday, that's 3 days from now. I'm going to be ready on Thursday. And the defense attorney says, well, I'm not available till next Wednesday. And then the judge says, well, I'm not available for 2 months from now. Only the 3 days are going to count for the speedy trial against the prosecutor, because that's the time that they ask for. And then there becomes issues with were they really ready or not ready. Not going to get into that now because there will be a huge debate on this panel.
Can I just
Yeah, go.
I think that the biggest problem, I think the biggest one is the court calendar, the court delay itself, right? Because if there's a bunch of misdemeanor cases on a court's calendar and both prosecutor and defense attorney are ready, but the judge is, I'm going to put it on for 2 months from now, then no time is going to count. That client's just out of luck for those 2 months.
Which, unfortunately, and it's hard to explain that to a client sometimes, that they don't understand why am I waiting 2 more months, because it could take a year or more for this case to finally come to an end. And, when you have a criminal case pending against you, you're nervous, you're stressed out. And what Brett and I see at the Manhattan Clinic sometimes is we have repeat clients coming in. They just want to give us a status update or just want like a mental, break and say, hey, this is where my case is. I still have another week. What's going to happen? And you tell them nothing's changed in the past week or the week before that or the week before that. But, just keep reassuring them. And then finally, in this case, John is still saying he's not guilty. So we're going to go to motions and hearings. So there's different types of motions. We're not going to get into the specifics of each one. Basically, motion to suppress the physical evidence. Motion saying there was no probable cause for the police to stop. Motion to suppress statements that the defendant made. So those motions will be made. It'll generally take a month or 2 months for the judge to decide on those motions. If the judge grants hearings, you'll then have the hearings in another month or 2. They'll then have a decision on the hearings in a month or 2. And then they can decide to go to trial or not. All this time, generally, the prosecutor is offering a disposition, and the defense attorney and the client have to decide if this is something that they're willing to take. So I don't have here whether or not John Doe was found guilty or not of criminal possession. That's up to you guys again. But I think it worked out quite well in the end. And this is just kind of an old graphic from 2012 that kind of shows how most cases in the criminal courts in New York are disposed of. So 47% of them actually end in a guilty plea. Whether or not, there's a big, debate and saying, well, a lot of them actually aren't guilty of the crime. They just wanted the better offense because the evidence didn't look so good. That's, again, between, prosecutors and defense attorneys. And, it's something we have to look at. Well, let's look at their background. Let's look at their, where they come from, the prison, the school pipeline, things like that. And the prosecutors generally will try and take that into consideration when determining whether to go forward or give a certain type of plea. So last thing just to point out on here, it says ACDs. Some of you may have heard of that. They're called adjournments and contemplation of dismissal. Basically for low-level misdemeanor offenses and marijuana first-time offenses. If you stay out of trouble for 6 months, which means don't get rearrested, don't do anything bad, don't have contact with the law in any way, shape, or form, come back in 6 months and your case is dismissed and sealed like it never even happened. So you're not always eligible for an ACD. Clients will come in all the time and they say, well, I heard about an ACD, I want that. It's like, number one, we're not your attorney. We can't get that for you. But also, it's not eligible in every circumstance. So kind of always try and lay out the possibilities of dispositions because sometimes the statute does not allow you to take an ACD, in certain cases. All right. And then, forgot about this slide. Last thing, fines are always a big thing. So whenever you have a criminal case, there's always court mandated surcharges, and then the judge can also institute a fine. So let's say that it's a petty larceny case. They can say, well, we're fining you $500 restitution plus your $120 court surcharge. If someone's indigent or homeless and they have to pay $600, $700, $800, that's never going to happen. So when you don't comply with the sentence, what do you think is going to happen? You're going to get rearrested for not, complying with the terms and conditions of your plea agreement. So if the client is indigent, generally judges will give a few tries. If they really try and they see this client is completely indigent, and a defense attorney can show these lack of funds, and a judge has two different options. When it comes to the surcharges, they can just enter judgment, which goes in the credit report, which, sometimes it doesn't affect, it really affects your life, but some people, that's really what they have to do. But entering judgment does not technically go towards the fines that are imposed. People do it all the time. Judges say, I'm going to enter judgment on the fines. You don't have to pay. We're going to enter judgment. Never happens. Judgment is never entered because they legally can't do that. They just say that they do. Or you can ask for an alternative sentence. You can say, Judge, my client can't pay $500 in fines, but can he have 10 days community service? A judge can vacate the original plea and say, okay, no fines. I understand your situation. Let's do community service. And on that, depending on your borough, community service is given in any way, shape, or form. People worry about losing their job. It's like, I can't miss work to go do my community service. So I'm not going to go to community service. You warrant, you get rearrested. The whole cycle starts all over again. In most boroughs, I know Manhattan and in the Bronx, they have every type of community service. They have desk duty, they have nights, overnights, weekends, so they can find something for you to do or place you with. In the other boroughs, they don't have that, but you can tell the judge, my client, as you can see, is, in a wheelchair. He can't do the type of community service that this court was recommended. Can we think about any other type of sentence? And that's a conversation, again, between all the parties.
Thank you, Anthony. And in our last 10 minutes, Debbie is going to talk a little bit about trafficking, commercial sexual exploitation, and immigration remedies.
Sure. I think Sharon had a question.
Yes.
So what should happen is there should be a control date. So what it is that your client will be sentenced to community service, and the judge will say, okay, I'm going to give you 60 days or 90 days to complete the community service. Come back here in 90 days. Here's a date, and bring proof of the community service. So generally, you always get a receipt. And then, you have to remember to go back on that date, because then if you don't show, they assume you haven't done it. And again, the cycle repeats itself. But that's generally, they always set a control date.
You get a certificate.
Yeah. So for court surcharges, a judge can enter judgment. So basically, it goes in your credit report that there is a, lien out against you that you weren't able to pay, a court ordered. It's like it's a civil judgment, essentially. That's what it is. And then you just don't pay it. It just goes in your credit report. My credit report's bad enough, so.
Debbie.
So I'm going to fly through the last couple of slides. So I'm going to be talking about some trafficking issues and some immigration-related issues. At the clinic, I have not seen a lot of immigration issues over the years. I mean, sometimes it has come up, and sometimes on weeks that I'm not there, an immigration issue might come up. So I think it is something to just keep in mind that it may come up with you. We talked a little bit about trafficking, sex trafficking, and I just wanted to sort of point you to sort of the internationally sort of agreed upon definition of trafficking, just to give you some context. It's actually quite broad, and so I think that's important. I think sometimes people have these sort of very antiquated notions of what trafficking is or what trafficking means, either in this with sex trafficking or in the labor context. So I think people oftentimes, just like the Law and Order, people think like you have to be tied up to like a radiator or like in a box or something like that. And that's not necessarily true. Some of the youth that I have spoken with at the clinic have engaged in there's maybe some sort of commercial sex that's happening, or, there's, I think what people call like survival sex, situations where it's very difficult situations. Maybe their landlord is sort of forcing them to have sex with them. There's different types of situations that come up that are very disturbing and very dangerous. So I think it's just important to keep this in mind. And as was mentioned before, if somebody is a sex trafficking victim, that is an affirmative defense for the prostitution. So that's important to keep in mind. So in terms of foreign-born individuals, so you might come across somebody at a clinic who was not born in the United States, or, sometimes I've come across somebody who said, oh yeah, my friend, he's not here this week, but he just came from Jamaica or, some other country and might have some immigration issues, but has not necessarily interacted with anybody. So I just wanted to very quickly go through some immigration-related options that, maybe something, it's again, not something that I think you need to sort of absorb fully, but just something that just sort of washes over you, and just to keep in mind. So in terms of foreign-born individuals who might be victims of either sex trafficking or labor trafficking, there is an immigration option that is available to them, and the formal name is T non-immigrant status. So this is the basic definition of T non-immigrant status and sort of what is required to pursue that. So essentially, what you're looking for is a situation where somebody may have been a victim of sex or labor trafficking, and they don't have lawful immigration status, but they may be concerned about sort of how do I maybe get out of this situation? How do I support myself? How do I sort of protect myself? Sometimes there are situations where somebody is foreign born, and that is used as a tool to maintain control over somebody, that I'm going to call immigration on you, or if you call the police or talk to anybody about this, that I'm going to somehow get you deported. Or I might get somebody else deported that so that's, or separated from children or other things like that. That's something that is unfortunately very common. So with the T non-immigrant status, it doesn't automatically give you a green card or citizenship or anything like that. It does give you this sort of interim type of immigration status. What I usually will tell my clients is that it's a stepping stone, essentially. It might provide you some protection. The United States government will give you some initial protection, and then at a later point, you will be eligible to apply for a green card. So these are common situations sort of at the bottom that might be sort of red flags for somebody to sort of talk about trafficking situations. So work without getting paid, or not getting paid what was promised, sometimes working and being told that you somehow have a debt, that you owe your employer actually money in a situation, or other situations where it's sort of being exchanged for something of value, maybe, a place to stay, food, basic survival. So this is in the Immigration and Nationality Act, this is sort of the way in which somebody is able to establish themselves to be able to obtain T non-immigrant status. So these are the basic requirements for it. But I'm not going to go into tremendous detail because we don't have that much time. Some additional issues that I did want to bring up as well. There are youth that we encounter who I remember one situation where somebody had recently come to the United States, and that person, was fleeing a situation in their home country where they were, ostracized or kicked out by their family, and they were trying to find a place. And unfortunately, they hadn't landed anywhere sort of safe yet in New York City, but they were at the clinic and they were sort of reaching out for assistance. So asylum is also an option that is available to people. It is for people who fear returning to their home country. And it is either the government or somebody that the government cannot or will not control wants to harm them for very specific reasons. And so for the population that sort of that we encounter at the clinic, that could be a situation in which somebody is being persecuted because of their gender identity. Maybe they're finally coming out, or they just came out to their family, or their family discovered this about them, and there has been all these repercussions within their own family, and they felt unsafe and they left. So that could be a type of situation. So somebody who has recently come to the United States, one very, very important thing about asylum is that you need to apply within 1 year of your entry into the United States. There are very limited situations where you can still obtain asylum if you file after that year of entry. But it's just very important to keep that in mind. So if somebody has been here and they've been here for a little while, it's important to refer that person to an immigration attorney as soon as possible. Finally, there is another type of, yes.
Especially LGBT
Mhm.
people
Well,
about
mhm.
what countries are deemed not going to get asylum versus Russia.
There are definitely organizations that specifically focus on asylum related claims. So there are definitely resources. But I think there's a lot of other information that, other immigration attorneys can provide. There's definitely case law. There's other things that people can look to. I wouldn't necessarily say that, everyone from X country is just not going to be eligible, because there could be, I think, unique circumstances for them. And I wouldn't want somebody to be discouraged from, at least exploring options, talking more in depth with an attorney about those options. Unfortunately, also asylum is a very long process too, so that can be very frustrating. So I think just talking to an immigration attorney, somebody who's a specialist in the area, I think is important as soon as possible, is very helpful. Yes. U visa is available. It's not just it could be for somebody who's a trafficking victim, but it could also be for somebody who's a victim of certain serious crimes in the United States. So that is also available. I sort of was trying to pare down the amount of immigration options. So that is certainly an option. So if somebody also has been a victim of a certain serious crime, they're foreign born, it could be a pathway, just like the T is, to get a green card ultimately. Yes. There isn't, but there are certain situations with the T context, with the U context, where there is some sort of engagement with law enforcement that needs to either be initiated, or there needs to be some sort of interaction with law enforcement. It could be that, say, with the T context, say I've been trafficked and I want to report that to the police. Maybe I report that to the police and they just do nothing with it. They say, okay, well, that's really sad that that happened to you, 5 years ago, but I'm really not going to do anything about it. That could be a situation, but you've reported it, you've interacted with them, but they're not necessarily doing anything with it. You might still be able to pursue the T. In the U context, it's a little bit different. You need to actually receive this specific confirmation that you were helpful in the investigation or prosecution. It's a little bit different, but there's not that sort of 1 year sort of deadline. It's just asylum is very unique in that way that there is this sort of ticking clock as soon as you cross into the United States, your last entry. Um, I'm going to move on to the next. So the special immigrant juvenile status is the last option. I just was trying to sort of pick and choose things that might come up more so with the youth that we encounter and foreign-born youth that we encounter. Even though there's not a one-year deadline with special immigrant juvenile status, you do need to apply before you turn 21. So for the older youth, it may be something that's a problem. So special immigrant juvenile status is another kind of humanitarian-based protection for foreign-born youth who have been abused, abandoned, neglected, or something similar to that by one or both of their parents. A very sort of common scenario might be there's many different types of scenarios. I have definitely come into contact with many youth who have been in the foster care system, have been involved with ACS, over the years throughout their childhood. Maybe they came when they were very little, but they still were not born in the United States. And maybe there were neglect proceedings. There were other things that happened. They may very well have been eligible for this, but maybe now they're 23 years old and they can't pursue it anymore. But there's also situations where a youth may have come to the United States, maybe that went more recently or maybe a long time ago, and maybe there has been a situation with one or both of their parents where reunification is not a viable option for some reason. For special immigrant juvenile status, similar to the T and the U, there needs to be some sort of contact with a government entity, and specifically with special immigrant juvenile status, a state court system. Usually that's family court here in New York. But the sort of marker for that would be for special immigrant juvenile status, again, is this idea of reunification. Somehow there's a problem with one or both parent that's in the neighborhood of abuse, abandonment, neglect, or something similar to that. So those are the very, very basic sort of immigration options that might come up. Yes.
This is sort of a magic bullet for a lot of.
Mhm.
One thing to know when you're talking
Mhm.
willing to petition.
Sure. No, definitely the guardianship issue, I think, for perhaps the youth, foreign-born youth that we might encounter in a clinic, that might be one of the biggest challenges. But I think that at least my approach oftentimes is, I just want to be able to sort of do the basic assessment and then sort of pull in and sort of build that relationship with the young person, because there may very well be somebody, it's just they might not readily identify them. And I wouldn't want them to just sort of, say, oh, this is not an option anymore.
Thank you, Debbie, and thank you to all of our panelists for this excellent CLE. I'm told that we have a reception as well. Is that right? And because we didn't have time for a question and answer session, except for the questions during the course of the event, I think some of us will stay behind to answer any questions that you might have. So thank you again, and please see me or Sharon or Everson if you are interested in being a volunteer for our clinic.